I've been on this bench almost 25 years, and never have I ever been insulted in the fashion you just insulted this court.
Why?
No. My turn. I'm sorry?
So I'm Thomas Styron, the living man, not Thomas Gilbert Styron, the entity you know me as, or as I'm on the papers. I'm not adjusting that.
All right. Thank you. You wish to be represented by an attorney, sir?
No, I'm here to address the appropriate persona.
All right. I do have to advise, so you're going to represent, you need to stand in the middle of the podium where he's telling you to stand. Check back there. I don't know that we're going to be doing all that, but let me ask you something. On the Styron matter, I sent my bailiff back to get him to bring him back out. The court is of the understanding that defendant number one is being, I will say, uncooperative, has purposely done some things to make it difficult to bring him out. What I'm going to do at this point in time, we're not going to wait and not going to play his game. We will hear him next week because of his behavior today before the court. At this point, I will revoke his bond and I will adjourn the probable cause conference.
Watch how quickly courtroom order clashes with ideology. He's asserting his identity over the law. Do you think anyone should get away with this? The judge isn't laughing. He's setting boundaries, showing who's really in control.
He certainly poses a risk to even bring him out. So I will adjourn this out to May 2nd, 2024, 9 a.m. or as the invite indicates. I will leave it there for the reasons that I've stated on the record. Mr. Mansour, he is not represented by counsel. If you would, for the court, take the opportunity to come back and to apprise him that of what the court has done and that I will see him next week.
Yes, sir.
The court feeling that he's being uncooperative and not compliant. All right. Thank you.
Thank you, Your Honor.
Thank you. Court does call the case, People versus Tariq Day.
I am Tariq Smart Tariq Day, the executor of the Tariq Smart Tariq Day Living Trust and the registered owner of the Tariq Smart Tariq Day Ex Relatione Kingdomon Wilson Estate.
Right. So you are appearing here without an attorney. I do have to advise you that you are charged with the offense of fleeing and eluding in the third degree under the Motor Vehicle Code. That is a felony punishable by up to 5 years incarceration and or $1,000 fine plus court costs. Additionally, the Secretary of State could suspend your driving privileges for up to a year. Do you understand that, sir?
I comprehend.
Do you understand?
I comprehend, yes.
The court has to further advise you that if you wish to be represented by counsel, the court will ensure that counsel would be appointed to represent you in this matter and that you would have counsel if you could not afford to hire counsel yourself. I also wish to advise you that the court would be treating you the same as it would the people in this case. There are certain dangers to representing yourself in this matter, in that you will be required to abide by the Michigan court rules, the Michigan rules of evidence, and all of the cases and statutory requirements. You understand that?
I do not.
You do not. What is it about that you do not understand?
It's against my religion to adhere or to assimilate to any statutory.
Sir, I'm not asking anything about your religion. It is irrelevant to me. I am indicating that in this proceeding, you will be required to abide by the rules of this court. Do you understand that?
I'm having a hard time understanding why or how religion doesn't play a role. If
How what?
how religion does not play a role.
Religion does not play a role in what I do or what this court does. There are certain rules of this court established by the legislature and the Michigan Supreme Court regarding how these particular proceedings will be conducted. These proceedings will be conducted in accord with those rules. Do you understand that, sir?
Well, according to the American Declaration on the Rights of Indigenous Peoples, as well as the international or the United Nations Declaration on the Rights of Indigenous Peoples, the state and the governments should.
Sir, you have no authority for what you're about to state because what you're about to state is incorrect.
Oh, I am an Indigenous person.
No.
So I do have.
Sir, what you're about to state is incorrect.
Well,
If you were on indigenous lands, if that's where you're going, then maybe you might be right. As it stands right now, this proceeding is not on indigenous land.
well, that's a matter of perspective, sir.
It is. And the only perspective that's going to matter on that is mine. We are not on indigenous lands subject to indigenous or tribal rules.
Is there a
We're
law?
subject to the rules of the Michigan Supreme Court as they are promulgated, both in terms of procedure and evidence. Do you understand that that's what's happening, sir?
I do not.
What is it that you do not understand?
I don't understand.
Because I'm going to tell you something, sir. If you are unable to establish or understand what I'm saying, and go through this with you again, I have to assume that there may be some reason why you don't understand. This court will take precautions to protect your rights, and I will be sending you for a competency evaluation to make sure that you are competent to stand trial and to stand in these proceedings.
Well, I would agree to a competency if the prosecution, as well as the court and the officers, agree to take a competency.
That's not the way it works. You don't get to make the rules.
I'm not.
I'm ordering a competency.
I'm not making.
Defendant is ordered for a forensic evaluation. I will set a competency hearing in this matter for July 25th, 2024. At what time? At 9 a.m. Now, sir, I'm going to ask you this.
Yes, sir.
Because it's going to depend on where you may be staying for a period of time. If they send you information as to when you have your forensic interview,
Yes, sir.
are you going to cooperate and attend that interview?
Under threat, duress, and coercion. Yes.
Pardon?
Under threat, duress, and coercion. Yes.
Notice how he claims cooperation only under threat, duress, and coercion. Isn't that just a fancy way of saying he's not following the rules? The judge immediately calls out the attempt to manipulate the process.
No. It's not how it works.
I don't.
I'm asking you, are you voluntarily going to cooperate?
I say yes.
Pardon?
I mean, under it, yeah. I mean, is this what are, excuse me, what are you relaying to in regard? What are you insinuating in regards to where I will stay for a time?
I'm going to make sure that we are going to have our forensic interview done. I've ordered a forensic interview. I am asking you whether or not, when given notice of that interview, whether or not you are going to voluntarily cooperate in that interview.
I will take the interview.
Excuse me?
I will take the interview.
Anything from the people?
With the court, ask the people to prepare the order for the competency.
Yes, please prepare the order for the competency if you would, sir.
And the address for,
The defendant,
I see on the complaint is 14.
is that your address, sir?
Excuse me? That's correct.
All right, very good.
I will send a copy to that address.
Very good. All right. This time then bond is continued.
Yes, sir. And I'm sorry. Can I get that date again, please, sir? I can put it in my calendar.
July 25th, you were supposed to, so I'm assuming you're waiving it. You were supposed to file your motion with.
I did. I filed it.
When did you file it?
I brought it in today.
Do we have it?
I gave it. I mean, it was stamped and everything. I gave it to the reception.
Why didn't you file it before today?
Well, as I stated at the last hearing,
No, don't go through what you stated at the last hearing.
well, you
I
asked.
knew that, no, you knew it was supposed to be filed before the day. Young man, you're going to
That's it.
figure out something. We're playing by my rules, not yours. So you know, do not say anything because you're going to figure that out real soon. Do they have it?
I have not received a response yet.
Since I'm sending in for a competency, I can't hear that. I can't hear his motion in any event. So I won't hear his motion at this time. He'll have to refile it timely if he's determined to be competent. So I'll have his bond continue. He can go.
I
What?
didn't get the last part that you said. The bond continued and what?
I said you can go.
Oh, okay. No problem.
I've been on this bench almost 25 years and never have I ever been insulted in the fashion you just insulted this court. In very, no, my turn. The case, the very first case, when you say the first case I called today was upon receiving a notification about something that I had considered in a bond, was notified that that had been located, this court, to the defendant's benefit, set that hearing. Without notice to any side, I set the hearing. So to be fair to all of the parties, I receive motions all the time regarding bond. And this court just seeks to be fair, to have a hearing. Now, having said that, so maybe you can put that in a little perspective. I heard you that you said you just got the discovery, can't go through it. Well, I'm going to give you about another 18 hours to go through it because I'm adjourning this hearing for two reasons. To allow you to go through the discovery, to give me a cogent argument as to why I should not grant what the people want. And secondly, because you have raised the ire of this court. I am not going to punish your client by what was one of the most ignorant statements I have heard about the conduct of this court from any counsel in all of my years. I will not, by any means, punish him for that. I do not make my decisions out of anger. I'm adjourning this to tomorrow, May 10th, noon. All the parties are ordered to be here. That is all. That is all. Noon tomorrow. Right. Court does call the case, People of the State of Michigan versus James Whitley.
People.
Your Honor, for the record, my name is Whitley. Pretty Whitley. I get Mr. Whitley stand to the right. Sir, please state your name. James Thomas.
This is a continuation of the hearing. Is there anything additional from the people?
Nothing additional from the people here.
Anything additional from the defense?
Nothing. Yes, Your Honor. One thing additional is that if the court finds that money bail is necessary, I believe that based on this case, an appropriate bail would be something like a $10,000 the current bond conditions regarding specifically a GPS tether with the exclusion zone and the drug and alcohol testing, I think, address what the primary concerns are in the report. He was intoxicated, and of course, he should not be drunk here. But the reason I think primarily that the $150,000 insurance bond was excessive is he has no history of any violence whatsoever. In fact,
Well, can I just stop you there? Because I have some concerns about the representations of what happened that were made to the magistrate at the time, and some of them made to me yesterday. I went back and listened to the arraignment. And my understanding is that the alleged victim in this case contacted the defendant to pick her up from Chelsea bowling lanes or something along those lines.
he went to Chelsea Lanes to make sure she got home safe because she was intoxicated.
Right. And then after that is when this ensued. I'm having difficulty. Well, let's put it this way. According to what I have, he shouldn't have been driving. That's number
Well, he
one.
wasn't tested. The allegation is that he was intoxicated. I don't believe he agrees with that characterization.
Mr. Bennett, do you know what you said at that hearing regarding intoxication? Well, first of all, I don't think there are two issues there. One, he wasn't supposed, my understanding is his license is revoked with restrictions. And that his activities in going there that night would not have been within his restrictions on his license.
Okay.
Right? Secondly, with regard to the incident, the indication is he was trying to get his keys to then drive again, which would have been outside of his restrictions on his license. And there was at least the indication when there was a talk of intoxication that the defendant at that time may have been intoxicated.
I believe I said exactly that. He may have been intoxicated. Can I address that concern or not?
Go ahead.
Your Honor, if that's the concern is that he was driving with this habit, then, an added condition that he can't be driving without a valid license.
No. My problem is with the whole story. Because why is he getting his keys to drive when he's not supposed to be driving? Is what I'm having difficulty even understanding the events as you're telling me they may have existed at that time.
The story gets messy here. Conflicting accounts, possible intoxication, and injury. Who do you believe, the alleged victim or the defendant? This is where justice and chaos collide.
She was intoxicated at Chelsea Lanes. He wanted to try to drive her home. She refused. She drove herself home. I think I haven't seen the alcohol test. I don't know whether or not she touched it or not. He followed her home to make sure she got there okay. The parties he had generally, I believe, according to the report, it's spent most nights there. Then they got into an argument and he tried to leave. couldn't find his keys, and that's when the incident with the bed and the phone and the last one came. I think, in my opinion, those sort of discrepancies are only, I guess, the absolute truth, I guess, would be relevant to the bond, but they decrease the likelihood of conviction when you have the alleged victim saying that her statements were entirely accurate, and wishing to recant, and him saying he was looking out for her. When the argument got loud, he had asked her to keep it down so the children wouldn't hear them arguing, because he was concerned about trauma they experienced from a prior abusive relationship. And telling her to calm down actually escalated the fight, and that's when the incident happened in the bedroom, which there's disagreement about what that was. That, at the end of the day, resulted in the injuries that were sustained by the alleged victim to her wrists, our arms, and the head. I would clear up, since you gave me a chance. There were actually, I believe the people said there were 3 gas cans, there were 4, there were 3 districts. I was able to do what they provided. But I think that the key issue in this bond is somebody who is a close friend, the alleged victim, has known Mr. Whitley for 20 years and said he's not violent, that this has never happened. So, regardless of whether or not there's a conviction for purposes of bond, he does not pose.
If I consider him a danger, yes. I mean, what I've got here is I've got somebody that shouldn't be driving, who may have been intoxicated, who would have driven on 2 occasions when he's not supposed to be driving, in violation of his restricted license, breaking the law. Then I have this confusion about the incident. I don't even know why she would have his keys if it now is you're relating to me that he drove and then followed her, which was not the indication that I got from listening to the arraignment. And then an altercation occurs that results in what I would consider significant injuries to the alleged victim in this case, to the point of a level of medical care that was required regarding that person, which I think would have been significant. And then from that, does she have to keep moving?
Excuse me.
And then, it creates in this court's mind a level of potential danger that this individual poses, potentially to the victim as well as to the community. It certainly raises that level, because he's not this law-abiding person that you say he is, because he's obviously driving. I mean, he's got those previous convictions, which led to the revocation of his license, which led to the restriction, and he's violating that twice that night.
The judge doesn't just set a bond. He frames the entire moral and legal context. This is a masterclass in asserting control while weighing public safety and fairness.
At least. So, I don't know. Sparoso, was there something else?
No, you're right.
Anything else, Mr. Bennett? Anything else, sir?
No, I just don't know. I hear that he was driving when he was. I guess he's violating this restriction. That doesn't warrant $180,000. Do think that it's like some cash bond is appropriate at this point. I think it should be something that powers, especially in case that the left is subject to election.
Understood. And what I am officially indicating is that in listening to what was the representations at the arraignment regarding what transpired, listening to what transpired that day, hearing what is today, it's unclear to me that that's what actually happened. Because that's not what's been said on the defense side about how this whole thing comes about. I then end up with an individual that is severely injured where they're at the hospital getting the treatment that they're getting. There's some indication that that's her fault. Maybe. But then, and that the defendant is trying to get away. I just find that version of events, it may indeed be true, but I find it, at least at this point, to be sort of remarkable that that would be it. The court, go ahead. What were you going to say?
I was just going to say, that sounds like that's.
Oh, I'm sure it certainly will, but I don't have that at this. It normally would during a bond hearing. I have to assess it based upon what I see, and I would say also, with all due respect to the magistrate of this court, that making a statement of giving a PR, but then indicating that the people might file an emergency bond motion. How she'd know that, I do not know. But that, from my perspective, leads the court to believe that it was in part of the court's funding, but also as a result of what the court is looking at in this case, would find that her decision to issue a PR bond was indeed an abuse of discretion in issuing that bond. The court will leave all of the conditions as she set in place. I will set the defendant's bond in the amount of $35,000 cash surety.
Now, the bond is set at $35,000 cash. Would you consider that fair? Should the law favor caution over second chances?
Defendant, you're mad.
Thank you, Your Honor.
The one. All right. Court stands at recess. Thank you.
All rise.
Today's case proves once again that internet legal fantasies don't work in reality. Sovereign citizen tactics might sound clever online, but in a real courtroom, trying to outsmart a judge with imaginary loopholes only guarantees a harsher sentence. The justice system runs on actual laws, not internet scripts. If you enjoyed this courtroom reality check, hit the like button, subscribe, and let me know in the comments. Do these defendants actually believe their own arguments, or is it just a desperate act? See you in the next case.